So let me just introduce Cameron Shaw. Cameron's worked here at SSW for many years before he went off and became a lawyer. He'll tell you more about that. But I can tell you that a lot of people talk to me about, especially other smaller guys that are trying to get up and running with independent contracting, when they're working for clients that are substantially bigger than they are, and they ask about how do we do that and how do we manage different clients. And I can say these days, we have a fairly smooth running consulting practice. We haven't had any project not go into production in the last 6 years now, but it hasn't always been like that. We've obviously been through a school of hard knocks, and Cameron has been with the company for a fair while before he's gone off and went off and did a law degree. I think that you'll see tonight a session that I wouldn't have minded seeing myself quite some time ago, because obviously you learn things the hard way, and it is a lot about setting up expectations. He's obviously going to have a bit of knowledge about how software works, so he should be able to tailor it to whatever you guys want and should be able to answer questions as we go. Okay?
After working at SSW for a while, I got involved in projects, contract negotiations, arguments with clients about this, that and the other. And I really, took it, got a taste for the legal side of things. So after a while, I went and got myself a law degree. So, and here I am back again. Now, being a lawyer, we fill our lives with disclaimers and caveats and warnings and the like. And so I have to tell you very clearly that this presentation does not constitute legal advice. So if you've got I'm here to give you some information, some tips and tricks about what's going on. But if you've got particular legal questions, I'm happy to take any questions on the way through. But anything I do say, I'm not really taking into account your personal or particular situation. I'll make general comments. You might need to go and get yourself some independent legal advice if you've got a particular legal question. So don't do things expressly on what I say. So if that means turn your ears off and walk out legally, then that's what I'm saying. But take everything I say here on the understanding I'm providing you with some information, and if you've got particular legal issues that you think need to be addressed, then you should go and get yourself a good lawyer. I've got a few lawyer jokes interspersed on the slides because we deserve those jokes most of the time. So feel free to laugh or not as you go through. Anyway, the things I want to talk about tonight is essentially matters concerning contract and everything that flows off of that. So the notion of, does anyone tell me what they think a contract is? Could they define what contract law is or how a contract works? Anyone got any ideas? Define what a contract is or how a contract works. Say that again a bit louder.
Agreement between two people.
Absolutely. It's an agreement between two or possibly more people. Now, it's a special kind of agreement. Anyone want to add a little bit more information to that word, agreement? Yeah, there's all those elements to it, which legal. Oh, perfect. That's exactly what we wanted. We want a legally binding agreement between a number of people. So it actually binds people's legal situation. So out of a contract, you've got rights. So someone's got these rights that they can go and enforce against someone else, or you've got obligations. So someone has all these things they've got to do in accordance with that contract. And the whole of life works off contract and a number of other basic laws, but we do that. The contract sets out the rights and the obligations between the parties. So I want to think about what those rights and obligations are, how do they arise, how are they defined, and the like. The issue that lawyers confront is when we're considering drafting contracts or getting involved in contract negotiations, is we think of the worst possible scenario that can arise. That's the situation we have to provide for. In business, when you're a software guy and you're speaking with a client, you're thinking everything's going well. You're being friendly, you're thinking you're going to work in a good faith environment and everything's going to be pretty. But the piece of paper that you sign or the term of the agreement that you finalise, that has to be drafted so that if everything goes up the creek, does everyone know and does everyone agree on what's going to happen in that situation? So we try and think about when everything goes wrong. So that's why we always think to the most negative outcome possible. I want to talk about how you as a software developer protect your position. What are the issues that I think practically about why ultimately you're going to get sued, and then of course if you know the answer to those questions you might be able to provide some solutions. Now I guess I just want to ask firstly, a show of hands, who here works for a software consultancy that provides a service to bigger corporate enterprise or bigger clients? All right, quite a few people. How many people in this room work for a large corporation and is a software developer within a large corporation? All right, so quite a different mix from the group in Canberra, which you might guess is has the balance the other way. All right, so from your perspective, how many people here make the business decisions? You know, the business is in their hands. They're on the line if everything goes to pot. Yeah, so there's quite a few people here in that position. From my position as a lawyer, I don't work for a big firm. I work for a smaller firm, and so my clients are people probably in your position who are fighting the big baddies out there. So I come at a little bit from that angle about how to protect a software developer. But if you just take your software development hat on and put your client hat on for a second, pretend you're the client, obviously what you're trying to do in that situation is try and screw the software developer down in a particular way so that he gives up all his rights and has lots of obligations. But you know, we can attack it from both angles. That's what we do as lawyers anyway. What I want to talk about first is just a first scenario, a factual situation, or describe a factual situation. And of course, anything I say here has any resemblance it has to what occurred in reality is purely coincidental. Let's say you're a software developer. You enter into a contract with another company called Northwind Proprietary Limited. The nature of the work that you're going to do is like a discrete internal management system. It's a system that only a few users are going to use. It's not a public site. It's something that you might have a number of managers across a number of states, but they're all going to use this system for running their business. In any contract, you're going to contract as a concept doesn't need to be written. It can take its form in a whole bunch of different ways. It can be partly written, it can be partly oral, it can be simply oral. You can even have a contract that's simply based on an interaction between two people where there's no words and no words spoken and no words written. When you buy a newspaper, you don't actually necessarily have to say anything, you just have to do something. But anyway, let's say you've got a written contract and it's got an aspect of it which is fixed price and an aspect of it which is variable. Is this a familiar situation? You're going to do both aspects. How many people here enter into fixed price agreements as a rule? A few people, not many. There's a few mad people in the room. All right. Probably more prevalent before Agile turned up to enter into fixed price contracts, but they seem to be going a little bit by the wayside in probably Adam's kind of business. But in any contract, you're going to have a fixed price element, and this contract has a fixed price element and a variable element. Now, what happens in any kind of situation is the contract's going to say certain things. There's going to be a standard form of contract, and it's going to say, as an example, that only so-and-so, a particular person in a business, can authorise work under this contract. Because it might be, especially under the variable price element, that there's a degree of scope which is to be agreed down the line. You might agree an hourly rate for that kind of work, And then it's going to say only, Mr. Northwind himself is the one who can authorise work under that contract and sign it off, and it must be done in writing. Has people seen contracts like that before that state very clearly how work is going to be authorised under the terms of that contract? But what happens in the course of business?
Delegation.
That's right. Something changes. People say, Mr. Northwind, just like we were hearing before about product owners being too busy, Mr. Northwind says, I don't want to hear about this anymore. I want someone else to take over the role. And so he delegates his particular responsibility under the contract to someone else. Okay, you might have a chat, and it doesn't happen formally, does it? You're having a chat with the boss of the company, and he says, look, I'm really busy at the moment. Go and talk to Barry, or go and talk to Julie, my secretary. She knows exactly what's going on. She'll tell you what to do. That's a common scenario in just general day-to-day interaction with your clients. The other thing is that the contract sets out what you're going to do. Obviously, the fixed price element's going to state it fairly clearly what's meant to be done, or it should. You're going to have the variable component the contract might stipulate, you need to develop these screens or this particular system. But inevitably, while you're talking to Barry or while you're talking to Julie, she says, look, we've got a real issue in this part of the business. We want you to create this new screen. We want you to convert this Excel spreadsheet into a bit more of a manageable system because it keeps crashing and falling over. So is that something that people have experienced, where they're continually changing something from what was agreed initially in writing? Suddenly the whole world changes through the course of the project. Probably as a developer you like that, because you're getting more work beyond what you originally provided. But ultimately the document that you signed didn't say do this, this, this and this. And then of course what happens in the end is something goes wrong partway through the contract. What inevitably occurs is that you've only completed a portion of the work. The client says software doesn't work, I haven't got what I wanted, and they refuse to pay. They say, well, you didn't get the work signed off by me. We didn't authorise that particular work. That's not in the contract between us. And so you end up in a dispute about with a client. Now, the challenge...
I have a question.
Yeah.
The question is, is there a chance of an Australian developer being sued by other developers from overseas if they infringe someone else's patent overseas? And he's specifically thinking of if he infringes someone's app in the App Store. Can he be sued by a non-Australian?
Yeah, all right. Well, there's a couple of things to say about that. The first thing is that concerns intellectual property law. And intellectual property law is an enormous area of law, particularly when it comes to patents. And if you want to become a patent attorney in Australia, you've got to do a whole lot more study after you do a law degree to go and become a patent attorney, and you've got to have another specialisation. You can only be a patent attorney, for example, if you've got another expertise in another field. So you might be a scientist or a food scientist or something like that. So what he's touching on there is the question of intellectual property law, and that's beyond the scope of contract law, because it's not about you don't have an agreement with this other guy in contract. So there's other obligations which exist beyond contract. So that's the first thing to say, is that you need to speak to a specialist IP guy. The second thing is to say that in terms of copyright, patents, trademarks, all that kind of stuff, there are international agreements which operate where, like Australia, for example, has ratified an international treaty on copyrights where we'll recognise the United States patents, they'll recognise our patents and the rest. So ultimately, because Australia has agreed to ratify someone else's patents, then we're subject to all the rules and obligations as if that other person was in Australia. So yes, there's a chance that you will be sued. So don't think that simply because someone's in another country, especially in patent law where it's particularly designed to cross international boundaries. All right. The way you guys work when you write code, I haven't seen people write code for a while, but I remember when I first started here, Adam used to code in a corner office with Access 2 up. And he was very good at Access 2. I don't know if he learned anything else beyond Access 2. Did you, Adam?
Oh, leave me alone.
But anyway, what you guys do when you write a piece of code is you run it straight away. And what happens? You get errors. Whoever writes code without bugs, you know. Good to hear, good to hear. But you produce bugs and you fix them straight away on the way through. That's the way you work. You can test your code instantly. You select those lines of codes you write, you compile it, you run it, and you work out whether you've got a bug or not. The big issue in contract is that there's no compile and test in contract law. If you enter into a contract today, you know, you might know whether there's a flaw in it for 15 years' time, you know, 20 years' time. And no one's going to be able to tell you which way it's going to go for a long time. And it's a real issue for lawyers because we're really trying to navigate our way through without being able to strictly test what's going on. So that's why when lawyers always get asked questions, we always just say, well, you know, it depends, because there's an infinite number of factual circumstances or things that can change on the way through. So, yeah, it's a real challenge to get contracts right, and you're never going to have absolute certainty until you're in court.
What does that do to the liability situation of a lawyer? Because if I hire you to write a contract and I realise 5 years down the track that it's got a fatal flaw in it, which should have been corrected at the time, can I sue my lawyer?
Yeah, absolutely. Lawyers are the number one target for people to get sued, often in most courts. The most important thing to bear in mind when you're contemplating suing a lawyer is what's called, or anybody, is what's called the statute of limitations. So there is a time period which starts, and you've only got a limited time in which to sue people. So in contract, in New South Wales, it's 6 years. And it's 6 years from the date of breach of the contract. So the date the contract was entered into is one date, but that's not necessarily the date it was breached.
So if you write a contract for me today,
yeah,
and it has a flaw in it, is that contract breached today, or is it breached when I discover
it may well be breached today, depending on the circumstances, or it may only be breached when a further situation arises. Yeah. So these are all the issues that are going to create complexity to your case. Because often in contract it's the date that you give the advice that is the... But then if you think... Don't forget, when you sue people, you don't just sue in contract. You sue in a whole bunch of other bases. Another way of suing someone is on the basis of negligence. Now, the time starts to run on negligence only when you've discovered that the lawyer was negligent. So you might not discover that until, you know, the advice turns out to be bad later on. Anyway, so testing a contract is extremely difficult, and it means that when you work with your clients on an ongoing basis, you've always got to continually revisit your contract, because just because you haven't had a trouble in the past doesn't mean your contract's good. The other thing I just want to mention is that contract is a little bit, in my mind, when I went through law school, a little bit like algebra. Lots of aspects of law are a bit like that. In order to be convicted of murder, as an example, what you've got to prove is two aspects. One called physical aspects and another one called the mental aspect. The first one is you've got to prove that you did an act which caused a death. So you've got to have those three elements. You've got to have A plus B plus C in order to get the physical element of murder. So you've got an act. So you actually got to do something. The act has to cause a death. So you obviously need to prove a dead body. An interesting case on that question is there was a girl, she was upstairs in a room in a unit block, there was her bikey boyfriend was bashing on the bathroom door and saying, you know, talking to her, I don't know what it was that she was saying, but, you know, probably yelling abuse at her or whatever. She jumped out the window, killed herself, or died. Well, did that act of knocking on the door and screaming at her, did that act cause her death, is the question. So you've got to have all those components. And then there's the mental side to it as well. You've got to do it with a particular intention. I won't go into all those elements now. But similarly for contract, you've got to have A plus B plus C plus D plus E plus F plus G in order to get the result that you want. And that's why lawyers always think about things that you don't think are relevant, because there's all these little pieces of the puzzle that we've got to put in to get a contract in the end.
So, Cameron, an example that's current is that John Singleton thing, where it looks and smells that something was wrong with Waterhouse, but all he could do was work with a comment like off, but he didn't have proof in between. Is that?
Yeah, that's right. That was an evidentiary question as to whether he could prove someone had said something. And what they decided in the end, as I understand, was no one could prove that someone had said something about the health of the horse. But a classic example of an element of contract is what we call agreement. And I think someone mentioned before offer and acceptance. So if you make an offer to someone, I'll do this work for $200 an hour, they write back and say, no, you'll do it for $150 an hour, and then you start work. On what basis are you working? You know, there's no agreement there as to what rate you're going to do. Is it 200 or is it 150? And so you have to have an offer that must be accepted. So you must have the offer, that's A. You must have acceptance of the offer, B, in order to get that condition of agreement. So, yeah, there's a whole bunch of little particular pieces in contracts that you've got to put together. And I'll go through some of these. I'm not going to go through these in details now because I want to go back to our scenario and talk about that. But these are all some of the various aspects of contract that you've got to piece together. Now, does anyone here trade as a sole trader? All right. So if you're a sole trader, people don't always necessarily, or if you're contracting with a sole trader, is people write, you know, when a sole trader trades, they trade under a business name, you know, best software in the world, whatever. The contracting party in that is the person themselves. You are contracting with a person because there's no legal entity called a business name. If you're contracting with a company, then a company has its own legal entity. But how many here who run their own business and run their business under a company name have a $600,000 property owned by that company as well, or a major asset also owned by that company? Or do most of you who run your own businesses have a company name and all your property and other assets is in your own personal name? That'd be the more common scenario, I would suggest. Why do we do that? Why do we put our assets in our own name or in our wives' names or our husband's name rather than in the company name?
Limits access to them from a liability perspective.
Yeah. That's right. And so when you're contracting with someone, it's particularly an issue if you're being required by a corporation, that if you're contracting with Superior Software for Windows Proprietary Limited, sometimes that corporation is going to want a personal guarantee or the like. Or if you're contracting with another particular entity, and especially if you're a software development company that does work for other small businesses, you need to think very carefully about who you're contracting with and whether you're contracting with a person, with a number of persons, or with a company. And if you're contracting with a company, what's the underlying asset position of that company if everything goes belly up and you've got to sue them? If they're anything like your company, there's going to be no assets there. So if you've lost a lot of money, if they owe you a lot of money, and all you've got is ultimately a shell company, then you're in a difficult position in terms of recovering any loss down the line. So, you know...
In the situation, if I have a contract with a company, XYZ Corporation over there, but when I come to sign the contract, I just know that it says XYZ Administration Limited or something like that, i.e. some company owned by the main company. I've seen that happen a couple of times where it's obviously been set up for some administrative reason.
Yeah, well, that's something you have to be particularly careful about. If especially with a big corporation, there's going to be lots of different entities under a group, and it may be that they use one particular company.
You have to repeat the question, so.
I beg your pardon. All right, I've just been told to repeat the question. So Greg's question is, what if you're contracting with a big company called, you think is a big company called Northwind Limited, but when you get the contract through, the contract is actually with a company called Northwind Contracts in Administration Proprietary Limited or something like that. Is that what you're...
Well, not so much an administration, but,
or a different company other than the big company you thought you were dealing with.
Number 2 Limited.
Yeah, that's right. Yeah. So what that means is you're contracting with Northwind Number 2 Limited. So whatever the assets and liabilities of that company are, if you have to go to court, that is the company that you will sue, and that is the company that you will need to recover against. So if that company doesn't have any assets, then you're in trouble. And the classic example of this, not in a contract situation, is where people have tried to sue the Catholic Church, because there is no such legal entity called the Catholic Church, incorporated in Australia, that most people have tried to sue for sexual assault and the like. What they've ended up doing, they've tried to sue the particular priest. Well, where's that going to get you? You're not going to recover damages from that. So it's very important, if you're a small business and you're contracting with other small businesses, that you've got to know exactly who you're contracting with. And I would suggest that if you can go and do a search on the ASIC website and find out how long that company's been around for. If the company's been around for 3 months, you've got to start wondering what is the nature of this entity that you're dealing with. Does anyone remember there was something in the news recently, I think, about Target importing some beauty products? Does anyone? No one reads the legal disputes section of the newspaper. So Target was importing some particular makeup from a company in Australia. The company in Australia was getting them from somewhere in America, and what they discovered was that the brand that was coming from the company in America was fakes. And so what's happened was the true manufacturer of that particular product has then gone and sued Target for basically breaching various obligations that it had on whatever basis. That company, the true manufacturer, has also sued that Australian importer that they would say knew what was the wrong thing, doing the wrong thing. But the point is that Australian importer has only been around for 3 months. It's got no assets. The directors of it have disappeared. So Target's left as a company, as I understand it, that's just doesn't have any way it's going to recover from being deceived in that situation. So if you're doing business with a small company, you should find out how long have they been around for. Should I get directors' guarantees from the people that you're dealing with? All right, I won't go through all these because I'll touch on them as we go through. But I will make this point about only contract ? As the final point. There. When I said before about that you'd probably sue in negligence, you could sue someone in negligence as well as in contract. The terms of the private agreement that you have between yourself and the other party is not the only basis in law on which the two of you will have rights and obligations to each other. Everyone's heard of negligence? Does anyone know where negligence came from? The famous case. It was handed down in the, I think it was in England or in Scotland in 1932. A case called Donoghue and Stevenson. Anyone heard of that? Anyone heard of the snail in the bottle case?
Oh, I've heard of it. I did it at university.
You did it at university?
Yep. I had to do one.
Did you go into the wrong class?
No, you have to do one subject of law, and I hated it. But I remember that because he drank from a bottle that was opaque, and he sued because I think he got sick from the snail.
That's right. That's pretty close. So what happened is this woman went on a day trip with her friend. She went to the local corner store in 1932, somewhere in Scotland, and she ordered it was actually a ginger beer spider. So the owner of the corner store opens this bottle of ginger beer and it's opaque, and he half pours out this bottle into the this woman's glass with ice cream in it. The woman's friend then pours the rest of the glass in after she's already taken a sip, and what emerges out of this glass is a half decomposed snail. And of course this woman suffers terribly. She goes to the doctor and she gets diagnosed with gastroenteritis. I don't know how much of the snail she must have eaten. And she's diagnosed with nervous shock, or with, she's obviously mentally distressed by the incident with the half decomposed snail. And we do hear stories about this from time to time when someone goes to McDonald's and finds half a finger or a bullfrog or whatever in their quarter pounder. Now that case, before that case, there was no principle in law called negligence. And negligence is where you as a person owe a duty of care to another person, and if you breach that duty of care and they suffer damage as a consequence of that breach, you can then get sued. So it happens all the time now in motor vehicles and medical issues. So you as a car driver have a duty of care to other people on the road that you drive carefully. So before that case, there was no such thing as negligence, and now it's everywhere. It dominates the law, particularly in America, where negligence suits are enormous. So when you're thinking about the obligations that you have between you and another party, you might strictly define them all in contract, strictly define the terms of the agreement between you and the other person, but it might be that the law of negligence cuts across that particular contract and changes everything. So it's different to what the contract says. The classic case of this is where you have a contract which limits your liability. Who here has a written form of contract which states that there's a limited liability that you would owe under the contract to that particular person? Yeah. And what's the normal way for how it's limited? What do you normally limit it to?
It's generally the spend on the contract.
Yeah, that's right.
A little bit more, but generally what's ever been spent.
Yeah, that's right. So, the comment was that the general rule is that you limit the liability to how much you've been paid in the contract, or how much the contract is worth. So if you do $40,000 worth of work, you try and contractually limit your liability to $40,000. Now the thing is that the law of negligence and other areas of law can just cut across that contract and basically get that term kind of read down by a court, or thrown out by a court. Not strictly thrown out, but the court won't find itself bound by it when it's coming to an argument about it. There's other areas of law as well. There's who's heard of the Trade Practices Act? Well, it doesn't exist anymore. So there's a new act called the Competition and Consumer Act, and that annexes to it the Australian consumer law, and it creates all these obligations on manufacturers and service providers to consumers. Has anyone bought anything recently, like even from Apple or Microsoft or whatever, and there's been a little extra slip of paper in the box that you've got that's referred to the consumer law? Does that ring a bell, or do you just throw out those pieces of paper?
Never looked.
Yeah. So when you buy something in Australia now, there's going to be this new warranty clause, which is very powerful. And it basically says, you know, if you don't like this, we'll have to give you your money back. You know, pretty much, not quite to that extent, but that's what it says. So that law is a new law. Well, it's changed the Trade Practices Act a little bit, but it's put a lot of power in the hands of the consumer. Now, who here thinks that when they're contracting with another company, that other company is a consumer? Yeah, the default position is they are until they're proven not to be. There's lots of particular rules about the Australian consumer law. One is when you're doing contracts for less than $40,000. You know, if you're doing a contract for less than $40,000, that really opens you up to the Australian consumer law. Would most people here who run small businesses do contracts on a regular basis for less than $40,000? Yeah, you know. So you're really exposed not only by the law of contract, not only by the law of negligence, but also by other statutory rules that cut across and affect your legal obligations and rights.
Cameron, I have a question from a live streamer, and basically he's saying, oh, look, I want to put an app into, I'm a little guy, I want to put an app into the App Store. I'm only going to charge 99 cents, but I'll get a lot of people. And how do I protect myself? Like, it's going to show the parents where the kids are. But imagine the app fails and it's not showing the parents where the kids are. Can I be sued? You know, and I only charge them 99 cents. He said, how much can that EULA, you know, the software agreement, stop them from suing me? and of course, the reason that the app would fail would be someone else, which would be Azure or Amazon Web Services or whatever.
Look, one of the issues with getting sued, and of course this, you know, when you're building an app, it's going to cut across international jurisdiction. So, you know, you have that part to think about. All I can speak about is Australian law. But one of the rules when you're suing someone is that you've got to prove that you suffered damage, so you suffered a loss, and the damage flowed from either the breach of contract or the negligence or some other breach by the person. Now, you know, I'm walking down some steps, there's a loose tile that you've known about, I slip on the loose tile, I break my nose. That's pretty clear that my broken nose is caused by your negligence in that situation. There's a rule that basically says the damage can't be too remote. It's called the rule in Hadley and Baxendale, if you want to write that down. But ultimately, it's got to be that it's within the contemplation of the parties that you, this is in Australian law anyway, that such damage might flow if you didn't do what you were meant to do. So if you think, you know, you've said this person, this app tells people where their children are. The child goes out, the app doesn't work, and the child falls over or gets hit by a truck and, you know, suffers some kind of loss. There's so many steps in between the failure of your app and the damage which flowed that the courts might say, look, that's too much of a stretch. It's too remote. The damage is too remote. The remoteness is the legal term, but it's just too far a stretch from the negligence, because, you know, even if you had known where the children were, would that have stopped the damage occurring? So, you know, just because you knew your child had been hit by a bus or was near that, you mightn't have done anything about it. So the courts are going to be reluctant to go that far. But having said that, obviously the EULA that you write has to take into account all these things and basically say, this app says, you know, we're going to do this, but the EULA is going to say, but we're probably not going to do it. Just like that Snapchat, which said, you know, it says we're going to delete it, and then the EULA says, but we can't guarantee that the files are going to be deleted. So you kind of, you know, and then there's a whole bunch of other issues emerging. So look, it's a risk to think about. You've got to provide for it. But if that situation occurred, you'd, driving the loss against you, it's going to be possible, but hopefully your lawyer's good enough to say it's way too remote.
So Cameron, before we said like in a consulting engagement, if the consulting engagement is for 100k, they can only sue you for 100k. Since they only purchased the app for 99 cents, can't they say you can only sue me for 99 cents?
Well, that's right, but what I said before was that the other laws will cut across that contractual agreement, and basically a court would say, well, we're not going to, the parties aren't bound by that limitation of liability that says it's limited to 99 cents. Look, you know, software is a whole new world in the App Store, and I'm sure Apple would actually provide developers with some kind of information about that stuff. So. But yeah, if you're buying something that's going to be consumed by the public in Australia, you're going to be subject to the Australian consumer law, and there's a whole series of obligations that are going to fall on you when you're providing something that goes out to the public.
Cameron, if I put out an app or whatever and say, this is what it's for, but you must test it to make sure it meets your requirements, does that cover me? And you know, I'm going to put all the if, buts and maybes in it. Might not be up at 100% of the time or whatever. But if I say you've got to take on the responsibility of testing it for your usage of it, so in that child monitoring thing, you've got to make sure it works for monitoring your children in your location. And am I covering myself a little bit more?
Well, you've got to be you've got to. Sorry, I'll repeat the question. The question is, if I summarise, if I say that my app does this, but you need to check it that it does this to satisfy you, does that cover you in a liability question? Well, my first response is that you shouldn't say things that aren't true. So if you say the app does this, the app should do it, as a general rule. So
the statement is that you need to test it in your situation. Because you might be using a piece of equipment that isn't compatible with my app, for example.
Sorry, say that again.
You might be using a piece of equipment or a software version which isn't compatible.
Yeah.
You know, it works on.
Well then what? Yeah. Okay. So the question is, what if your app integrates with a third party or something like that? I guess that's where you say you're actually limiting what you're saying the app does. This app works this way, but does not operate with third parties. And so what you need to do is you just need to say the limitations of your product at the very beginning, because there's a very important part in the Australian consumer law called misleading and deceptive conduct, and you can't engage in conduct which is or is likely to be misleading and deceptive. So if you say X but Y is the case, then you may be breaching that statutory provision. So what you need to do is say, this app does X in this situation but does not do Y. You've got to be pretty clear about what your software actually does and doesn't do.
So you open yourself up to class action as well. If it doesn't do something, especially an app.
Yeah, well, that's right. I guess my comment on that is I understand that a particular law firm has been, in investigative process of a class action against Vodafone for failures or issues with service from some years ago, and I think that's been going for 2 years now, that investigative process. There's that Vodafone website. I think he got a lot of publicity out of it. But look, if you're a little guy that's working out of his back shed, lives at home, I think if someone wanted to bring a class action against you, well, if they want to make you bankrupt and spend 50 grand going down that path, bring it on. You'll suffer the pain, but you've got to think that lawyers think practically as well, and if there's nothing to be gained, then you've got to, it's unlikely that it'd be a pretty brave person that took action. And if you think, Vodafone, there was people raised issues there, and that hasn't, as far as I know, or I haven't seen much in the courts about that. So, even when you've got a lot of people complaining about an issue, it's not like, Vodafone's immediately been sued, as far as I can tell.
Sorry,
regards to developers, to what extent are we liable to negligence as a result of hacking?
All right. Well, I guess the question is how liable are developers to issues which flow from hacking? I guess the first thing to say is that, did you develop an app which you said was secure? Did you take reasonable care in making it secure? Did you put a security system in place? So what I'm trying to apply the law is you've got a duty of care. The duty of care may or may not be that you write a secure app. It depends. If someone says, I just want an app, it's only going to be me and my company using it, I don't need security, then you've got an argument to say that it wasn't within the scope of the duty that you actually produce a secure app. But if you're producing an app that's out to the public and people are going to be putting their private details into your app because it's a convenient app for saving credit card numbers or birthdays or whatever, then you've probably got an obligation to put security into that app. If you failed to do that, and if the hacking was someone could just press a button and all their private information came out, then that's probably you stuffing it up. But if they've literally done some kind of hacking wizardry to get in by finding some flaw in some other system, then it's probably that wasn't necessarily a breach of your duty of care because you did what was reasonable in the circumstances, and it wasn't reasonable for you to design a system that couldn't be hacked into by someone from anonymous, who spends all their days doing this, that and the other. I mean, even if it was a breach of the duty, then you've still got the question of what damage flowed from that breach, and was that damage attributable to your breach or was it too remote? So I guess the point is everyone asks, can I be sued for? But there's so many steps on the way, the algebraic equation, that even if you get A, B, C, D and E, if you need F, if you need the damage to be not too remote and you fall over there, then they're going to fail in their suit against you.
Is there a requirement of developers to develop software that's fit for purpose? You see more and more products on the internet with the terms and conditions, and like this product will be really unlikely to work in all circumstances, it may break down. It's so negative, it's almost like if it worked at all you'd be really surprised. Do they really get protection by writing such negative terms and conditions?
Look, there's an infinite number of answers to that question. It depends on each particular factual. Oh, sorry, repeat the question. The question is, can you say, is it a requirement that software is fit for purpose? And if you say in your disclaimer, this software may not be fit for purpose, does that get you out of an obligation to provide fit for purpose software? Well, there's an obligation that if you produce a product that it's fit for the purpose that you say. And so what it comes down to is what purpose are you saying this product is for? So if what you're trying to do is kind of by, what's called fluff, just say, all sorts of stuff about how good you are, best software developers in Sydney, that might not be really making a clear statement about what you're actually going to do. And so what you do in the disclaimer is say, well, this is actually what we're going to do. We're only going to do this particular piece of work. We're only going to solve this particular problem, even though the fluff says more than that. So the issue is that you've got to decide what the purpose of the software is, and if you're going to make software for that purpose, it should be fit for that purpose. So you need to limit what the purpose is if you're going to limit the... Yeah. So the Australian consumer law cuts in there. Basically says if you buy something, it's got to be fit for purpose. But there's a whole series of, considerations in that. If you're buying something for 99 cents, then it might be that you shouldn't run a multi-million-dollar business on something that costs 99 cents. Like that doesn't make... That's not the purpose of that app that it run a multi-million-dollar business. All right. How am I doing for time? Just keep going on. All right. All right. Okay. Coming back to my question with Northwind Proprietary Limited, I just want to highlight some of the issues that emerged or that could emerge in particular software projects, and kind of highlight some of the, I guess, the solutions. The first issue is invoicing. How many people here have a perfect invoicing system that invoices their time every week? SSW does have a pretty good invoicing system, and I think that some pain that SSW suffered in the past led to this really good solution to invoice regularly. Because what invoicing regularly does, it does two things. It puts everyone on notice of what your understanding of the contractual relationship is. If you are sending an invoice on the Monday for the work you did in the previous week and you're billing them 40 hours, then that other side is on notice that your understanding of the contractual relationship is that you're billing them for your time that you spend. If they then pay that invoice, then they're basically, in a sense, agreed with what you've done. Or if it's different to what the written document says, they're kind of agreeing to a slightly different state of affairs than what the written document says. So it's really good from a contractual situation to send out regular invoices. Even when you're in a dispute, even when you're having an argument with a client about invoices, keep sending your invoices, because it's continually showing that you're engaging in work and that you're expecting to be paid. I think before a dispute operates, it's good from a practical commercial sense, because the worst thing in business is a surprise. So it reduces surprises. The second thing that can emerge in issues before, where you have Mr. Northwind says, go and speak to Julie, the secretary, and get some instructions from her and do the work that she says, is to bear in mind that contracts can be both written, they can be oral, or they could be partly written and partly oral. And you've got to bear in mind that when an oral conversation or an oral contract emerges, what do you think you should do?
Document that.
That's right, you should document it. And how should you document it?
As per a conversation email.
Yeah. Well, that's exactly right. And who do you send that email to? Mr. Northwind. You start putting conversations in writing and you start CCing the relevant people. This is important as well when...
Just the point of operations, how you do things. I've got a contract with Adam. He's delegated to you for management of it. You and I have agreed on something. Are you saying I should send my email to Adam? I think that's rude. I should send it to you and CC Adam. Now, have I then diluted the value of it by CCing him?
Can you repeat the question? Because I was distracted in my own mind. You repeat the question.
He was basically asking, does it make any difference if they're in the to or the CC?
Well, you should ask James Murdoch that, didn't that come up in the... in that inquiry in America, in the UK about the phone hacking. I think there was an attachment or an email all the way down the line, and it wasn't drawn to James's attention that a particular set of circumstances was the case, and he said, "No, I never saw that email."
Yeah, I think it was sent to him, but he said he didn't read it.
Yeah, look, it was in an email down the line. So there's a degree to which you should draw. There's an answer which you would, if I was acting for you, I'd say no, it doesn't matter. As long as Adam got it, that's all. Yeah. But I would say to protect your position, send it for the attention of the person who matters, who makes the decisions, who's going to be able to do what, whose authority you're relying on them delegating. There's a classic case in car parks. I think a judge by the name of Lord Denning, who was a wonderful British judge and said all sorts of wonderful things. He said that if you're wanting to waive or limit your liability and you're the owner of a car park, there should be a big red hand pointing to the disclaimer that's a sign on the side of the car park. That's what he wanted. He wanted a big red Coles hand saying, read this disclaimer. And there's a degree to which what he's saying is, for the avoidance of doubt, make it very clear that the person who matters gets the information they need to get to. So if Mr. Northwind is the one who says, go and speak to Julie about this particular work, then you email Mr. Northwind and you say, Mr. Northwind, as per our conversation, X, Y, Z.
So Cameron, in our company, you have to CC the product owner in every case.
Yeah.
So if somebody else is giving instructions, as long as those instructions have the product owner CC, that's fine.
Yeah, all right. Well, that's a company policy, and I can't say whether that company policy would be effective if it came up in court as to whether or not the product owner had the authority for that work. It had given the authority for that work if the product owner's authority was the case. One thing that matters in business is what's called a course of conduct. If this is the way the parties operate over a long period of time, it's pretty hard to say, no, that's not what the contract says.
I'd like to ask a question with regards to oral, and particularly the expectations from the salespeople. So I've been in a situation where salespeople went in and did a sales job. There's a big travel agency network in Australia, and it was like they said, we promised the world and everything. Then the contract was drawn up, and then when we did the job, they said, well, hang on a second, you said you'd do this as well. And they referred back to a conversation that happened as part of the sales process.
All right, so I'll repeat the question because I've remembered to do that now after the fourth time. What happens when the written document isn't in concord with the oral representations of the salespeople, and suddenly someone says, hey, someone told me it was going to do this, and it doesn't, and the contract doesn't say it. Well, there's two aspects there. There's a whole series of questions there. Often contracts say only things written in this contract are the terms of the contract, and no representations outside of it are to be incorporated into this contract. And on that basis, you would say, well, the written document doesn't say it, so it doesn't get done. However, there's all sorts of ways around this kind of situation if you're fighting for the client on that side. And they would say, well, we entered into a contract that it would do X with the salesperson. That was a contract. And that contract is a collateral contract. And then we only entered into the second contract because we entered into the first contract. And so therefore, even if you've got a clause which says, in the second contract, the terms of this contract are wholly comprised within this document, if you've got a second contract, it's not as if this is just another term of that contract that you're trying to get into the second contract. It's actually a second contract that sits alongside. So, yeah, there are always issues with that. In terms of what salespeople say, a really important part of a representation that a salesperson makes is it a promise? Did they promise, in a legal sense, that this was going to happen?
In this case, they felt that they had.
Yeah.
We ended up doing what?
Yeah.
Big company.
That's right. And what that highlights, that in many cases you take a commercial approach to disputes, because having a fight in court over that is just going to cost everyone a lot of money. And what it does mean is that salespeople need to be careful, and they can't just rely on the fact that they're salespeople and whatever they say doesn't matter. Yeah. So similarly, when an oral contract comes in place with variations happen all the time, and you need to document the variations to any contract that you go through. The issue of authority, who has authority in a company. Adam, you have a favourite term for who has authority in a company, don't you?
You're talking about company account?
Something about organs or something?
Oh, yes. Yeah. Do you want me to tell us?
Yes.
Well, we had this situation that arose where the client wouldn't pay for... Yes.
You're on mine.
No, I'm not. I'll get closer to Ken. We had this situation where 15 years, 12 years ago, we went
12 years ago.
We went to court and the judge had to decide whether we were going to get paid for all the work we'd done. Because we'd clearly done the work and we had clearly been given instructions to do the work, so I assumed that meant they had to pay. But the judge who handed out his decision 9 months after it closed for some reason, I always thought they'd give the decision on the end of the day. Very frustrating. He said, I've decided that all the bills where the product owner essentially was CC'd had to be paid, and any of the bills where it was just other people in the company without the product owner being CC'd don't have to be paid because the organs of the company didn't know.
The management organ.
Was that?
That's right.
And I said, what the hell? How does the company have organs? I haven't heard of this. Anyway, so the managerial organs of the company must know, and that's why I referred to it being important that product owner was always CC'd.
Yeah. So it is, you know, when you're directed to do something by someone who doesn't normally have management authority, you need to kind of put a practical hat on. There's a whole series of rules about working out who has authority in an organisation to do certain things. If you ask a lawyer whether, you know, a company has agreed to a particular agreement, the first thing they're going to look at is there a clause that says, you know, this document executed pursuant to clause 127, open brackets 1, close brackets of the Corporations Act, or not, and has it been signed by 2 directors or director secretary and all the rest. Like, lawyers will drill down to executed documents to that particular degree and make arguments about whether it's been executed properly and agreed to by the company. So if you're dealing with a whole series of users in a company and trying to get instructions from them about what to do, you've got to think very carefully about whether those users have authority to spend their company's money. And so while if it came to court, you may or may not get awarded the work that you do according to what a user tells you to do, it's a lot better to think carefully about making sure the person who you know does have authority understands or knows the work's going on. At the same time, sometimes if you're a software operator and a contract says X, it might be that, you know, work will only be done on the signature of so-and-so. It might be that without anyone saying anything, you just end up doing work that someone else tells you to do, who's not that person that says, you know, must be authorised in writing by Mr. Northwind. You just start doing work, you know, that Tim says, hey, can you do this? If you then send an invoice, say, you know, work requested by Tim, and then Northwind Proprietary Limited pay that invoice, and that happens a number of times, it's almost like you're developing a course of conduct where Mr. Northwind had a contractual right to say, I'll only pay for work that's been authorised by me in writing, but he's what's called waived that right. He said, you know, well, I know I had that right, but I didn't enforce it on the way through, and I allowed work that Tim asked to be done orally to be paid for. And so, you know, you've got to think practically. You can't manipulate your client or be deceitful in the way you go through, but in the course of a contractual life, often things are going to be done different to what the document says, and sometimes that can work in your favour. All right, covered that. All right, this next one, without prejudice savers to cost. Has anyone seen that written on a piece of paper by a lawyer before?
I've seen the without prejudice, not the rest.
Right. Does anyone know what it means? All right. It's essentially, the way the courts work is that they don't want everyone going to court. They want to stop people going to court as much as possible because the courts are busy. Judges maybe would perhaps have an earlier and longer morning tea than they normally get, and they still have lots to work to do. And the courts are very stretched. They're paid for by, state governments for the New South Wales courts, and it's very expensive to run. So there's a policy that basically says we want parties to be able to solve their problems between themselves without having to come to court. And there's actually a section in the Evidence Act which says that you can't adduce evidence of negotiations in a proceeding. But just to avoid any ambiguity or misunderstanding as to whether something's a negotiation or not, there's this phrase called "without prejudice savours to costs," which you can preface in any. It's not a magic phrase, but it's a useful phrase. It's in any oral discussion or in a written document where you're basically trying to compromise your position with your client, as an example. So if you've sent a client a bill for $15,000 and they say, look, we'll pay $10,000, then what you can do is, and all these kind of things, in any situation you should speak to a lawyer to get particular advice, but if you preface your letter back saying, look, without prejudice savours to costs, I'll agree that you pay me $12,000 instead of the $15,000 in full and final settlement of the offer. If you don't resolve the dispute and it comes to court later on, the other side can't say, look, he admitted that the work was only worth $12,000. Otherwise, he wouldn't have said, I'll take $12,000. We're now arguing about over how much the work is worth or whether it should be paid. They can't then bring that up as evidence against you as an admission that you knew the work was worth less than what you were actually trying to get, the $15,000. And so while I say yes, it's not a magic phrase in any sense, but it's a useful phrase to try and encourage negotiations where you can openly say something that's less than your contractual rights as you would see them without prejudicing your contractual rights.
Cameron, I want to push back on that being a useful phrase because I can tell you that as soon as you mention that, the relationship is terminally damaged by putting that stuff.
All right. Well, terminally is a bold statement, and so it is a commercial question to think about whether you want to do this. But I would say, speak to a lawyer, get the lawyer to tell you to do it, and then blame your lawyer. And people always hate lawyers, so just say, look, my lawyer, I don't know why, but my lawyer told me I had to say this in order to protect myself. So sorry, but I've got to say it.
But you wouldn't be in that situation if you're billing money every week and they haven't been paid for 3 or 4 weeks. Then you're in a relationship probably where things aren't working now.
Yeah.
So you would then say, well, look, if you pay me 75%,
Yep.
I want to quit. That's when you would use that situation.
That's right. And look, yeah, that's right. It might be that the relationship is broken down already, but yeah. Greg's question was simply, hasn't the relationship broken down anyway, so why do you bother trying to be polite? Is that what you're saying? Yeah. Well, yeah, so I guess the point is, in any space-time continuum, to use the language of Back to the Future, which is a favourite movie of mine, there's a happy relationship and there's a destroyed relationship and there's an infinite number of points in between. My point is that in any situation, you want to be very careful about waiving your contractual position or indicating that you're willing to accept less than your contractual position unless you do it on a without prejudice basis, because that can be used, they may try to use that against you down the line. So my point as a lawyer is protect your contractual position. If you want to find a way to try and make that sound nice or blame your lawyers for the language, that's fine. But our advice is protect your position. Commercial considerations is another aspect which we don't provide advice on. That's not what lawyers give advice on about how to be nice to your clients.
Cameron, you'll love this one. We've just had a comment from one of the live watchers, and they said, I'm a full-time dev, and this is one of the best talks I've seen at the user group for a long time. You should bring Cameron back for part 2.
Is that my wife? All right. Now here's another cool phrase, quantum meruit.
What?
So this is really important in building contracts, in home building work. Now Marlon, you used to be involved in home building, didn't you? Have you heard of this phrase, quantum meruit?
Is it English?
Oh, I guess it's Latin. I guess you always had happy customers, did you, Marlon? Yeah, good. It's quite true. Anyway, what happens is, remember I said before that you make an offer to do for $200 an hour, work for $200 an hour. They reply back and say, no, well, I'll only pay you $150 an hour. You then turn up on Monday anyway and start working. Maybe you didn't see the email, you didn't notice that they rejected your offer, you just ignored it. They didn't say anything to you when you turned up about what the final price was, you just started working. A court might find that when you go and do 2 weeks worth of work and you ask to be paid at $200 an hour or whatever, a court might find that there was no concluded bargain between you and your client because there was never an agreement. There was an offer, but there was no acceptance of the offer. There was just a simple counter offer put back. And so in order to get a contract, the first thing you've got to have is an agreement. Well, in that situation, there's no agreement. So a court might find no agreement. So what are your rights? Is there any way to get paid? Well, thankfully, there's this principle in law, because judges are very nice people who always think about poor software developers getting screwed by someone. They always think, how can we pay this person? And they always think this about poor builders that have been screwed over by a homeowner who won't pay them for the bathroom that's been built. And that poor, terrible builder won't be able to feed his family the next day unless the judge intervenes and says, even though there's not a contract, we'll find a way to get you paid. So there's a principle called quantum meruit, which basically means the merited value, I guess. I'm not a Latin scholar, but we can all guess what that means. And a court will find that someone cannot be unjustly enriched at your expense. They cannot receive the software development work that you did and not pay you simply because there was no contract between you. So you would file a claim based on the legal principle of quantum meruit. And so what you would do as a software developer is say, well, this is the scenario. They were offering, I wanted 200, they offer 150. Here is my expert witness. My expert witness comes in and says, software developers are worth $280 an hour. So I'd like to be paid my 80 hours at $200 an hour. And the judge is, just 1 second, Dad, the judge is going to say, well, no, I'm not giving you 280 because you would have done it for 200, but I'll give you 200.
Mr. Northwind counter offered at $150. Are you turning up? Is that not acceptance?
It may well be, depending on the situation. Oh, sorry, the question is, did you accept the offer by turning up when you received an email saying $150 an hour? Well, the question becomes was there actually an agreement of that? Was there a meeting of the minds on that situation? So if you didn't see that email or you weren't notified of it at the time you turned up, then it may be that it's not deemed acceptance. But yeah, that's an argument. But that would be, you would then walk into court and say, I'm happy to get paid $150 an hour because I accepted that. If that's going to be an argument you raise. That's why you might go the quantum meruit and try and get more. All right, another cool phrase is this one here. It's simply the French word for stop. But as lawyers, we like to make things more complex than it could be, so we choose a French word. The there's a wonderful case that built this situation. Does anyone remember an organisation called Walton Stores? Remember a company called Walton Stores years and years ago? Gee, what a young audience.
Is this about the morning tea example?
The morning tea?
Yeah.
No.
Okay, that's what I heard about.
Yeah. There was another case that goes back to post-war time actually in England called High Trees. Anyone heard of the High Trees case? Ah, see, you don't know what you're missing out on.
Of anything, Cameron. We're not lawyers.
It's all exciting stuff. So this is basically about, do you act conscionably? Do you act in good conscience with the people that you deal with? So the Walton Stores case is, there's a company called the Walton Stores and they wanted to lease a property down in Nowra. And the reason why they wanted to lease the property down in Nowra is because they wanted to build a store there. And they wanted to, enter into a really long lease, which we know are really valuable things for companies, to trade their goods. And they spoke to the owners of the land, whose name was Mr. Ma, and they said, we want to lease your land. And he said, great, it's land in Nowra in the 1980s. I can't imagine there was a massive demand for long leases from good commercial tenants back in Nowra, down in Nowra in the early 80s. It might not even be that good now. And what happened was that what Walton Stores said was, but if we're going to lease your land, we want you to knock down what's on there and we want you to start building something else for us. So it's a normal rule, isn't it, that if you're going to enter into a lease with a landlord, that you say, look, as part of the lease, I want you to fit out my property, fit out the land, fit out the strata suite for me. I want you to, put some whatever in and make it nice and pretty, and then I'll lease it. And so what Walton Stores did was it said, when it was asked, are you going to go ahead? They kind of indicated that they were. They said, yeah, we're going to go ahead. But they gave express instructions to their solicitors to said, look, just go slow on Mr. Ma's, this deal, this lease with Mr. Ma. Just go slow on executing the documents and going through because we don't want to bind ourselves too quickly. And Walton Stores watched Mr. Ma wheel in the bulldozer, start knocking down his house, start knocking down the land and start pouring concrete for a foundation for a new place. And then after watching Mr. Ma do all this work for about 4 weeks or 6 weeks or whatever and laying foundations, they said, look, actually, we're not going ahead with the lease. We've decided we're not going ahead. And that kind of sounds a bit immoral, doesn't it? But up until that case, that was fine. Up until that case, that was fine. They changed the law in this Walton Stores case and said, you can't do that. You can't make a representation. You can't tell someone that this is going to be the state of affairs, we'll enter into the lease, and then watch them go and suffer, spend money, incur detriment, do all this thing just for your benefit on the basis that you might do it, and then resile from what you said. Pull away from your representation. The court says we're going to hold you to that representation or we're going to make you make good for the damage that someone suffered. So Mr. Ma got a whole pile of damages from Walton Stores for the fact that he knocked down his building and started doing some construction work, and I'm not quite sure what happened with the lease and what was finalised there, but I know the court was quite generous in what it gave to Mr. Ma. So what that means is another example of where no contract exists. You don't have a lease, you don't have a signed document. In fact, you haven't even said expressly, this is the case. You've just said, look, we're going to go ahead, and you haven't actually gone ahead. You can be bound to what those representations are that you make. So it's, I guess, an example of if, let's say, you're a software developer and you're thinking of, entering into a hosting relationship with another hosting company, another small business, and you say, look, I want to enter into a hosting relationship with you guys, but we're not going to do it on the basis of your current hardware. you need to upgrade your hardware before we do that. And if you say, look, we're going to go ahead, and then you watch them go and spend 30 grand on servers and all that kind of stuff, and then say, oh, bugger it, we're not going into that contract. If you've watched them do that and it's unconscionable for you to resolve from that situation, you can be held bound to recoup something to that hosting company, whether it's the cost of the project, the hosting, or the cost of the new servers, or all that kind of stuff. So the court holds people to representations which they make when they make them in an unconscionable scenario. Now, once again, it doesn't mean you're bound to everything that you say whatsoever. There's a whole series of elements to tick off in the algebraic formula in order to get damages under estoppel, but it's a very real situation.
So does the court decide that essentially you've entered into this contract by sort of indicating that you're going to do this?
No, they don't say that a contract exists. Sorry, the question is, has the court decided that you've entered into a contract? No, the court won't say that something is the case which is not the case, because there's no contract entered into. So the relief that you get, the damage that you get, is not a damage under a contract, it's under the basis of estoppel. It's under an equitable basis. So you're still getting damage, it's just not damage under a contract, it's damage under another area of law.
If the hosting, if say you express interest in the hosting company's services, but you also say like, no, I think that your servers are too slow, and they go off and upgrade those servers without asking your permission or getting back to you or telling you.
Yeah, excellent question. The question is, if you go and talk to a hosting server and say, look, we would enter into a contract with you if you had these servers and provided this speed, and then without your knowledge they went and upgraded their servers and upgraded their speed, is this situation, is this estoppel? Are you going to be stopped from denying the agreement or the effect of the agreement? The answer is no. There's one of the very important elements in estoppel is that you intended them, or you knew that they were suffering detriment, and you intended them to rely on your representation and to do certain things. So in that case, you've got no idea what they're doing. You haven't told them to go and do it. You haven't gone and told them that there is a contract in place. You've just said, look, your service ain't good enough for me unless it's X and Y, which is what we need. So yeah, that just proves that there's a whole series of elements that you have to have to prove before you are successful. So it's never particularly easy. So remember what I've said about law being about specific elements, specific contractual algebraic system, if you like. You've got to have this, this, and this, and this. Well, this is how most people view the law.
All right. Give me one moment, and I will. It's the Constitution of Australia. This is a blatant violation of the Constitution of the Commonwealth of Australia. And when it comes to violations, they don't come any bigger.
What section of the Constitution has been breached?
Section? What section? There is no one section. It's just the vibe of the thing.
I'm afraid, Mr. Denuto, you'll have to be more specific.
Oh, yeah, sure. No, I was just starting general, and then I was getting more specific with it. Just one moment, please.
Jesus, Darryl, I am sweating here. You're killing them, Dennis. I don't even know Roman numerals.
I've got it here as the section 51, second from the bottom.
The Parliament shall have power to make laws with respect to copyrights, patents of inventions and designs and trademarks.
It's all part of it. This is what I'm getting at. That's my point. It's the vibe of it.
All right, taken. Do you have a precedent which supports this vibe?
Yes. Yes, I do. Just one moment.
What's the name of the famous Aboriginal?
Cathy Freeman.
No, the court case.
Yvonne Goolagong.
No,
Mabo.
Yeah, so essentially what that proves is that when you're in a court, there is a whole series of specific things to prove. You can't walk in and talk about the vibe. You've got a whole situation of, whole series of elements to prove. And if you fail on any one of those elements, your case is going to fail. Right, all right, how am I doing for time, Adam?
You're doing well. And that guy said that, no, he's not your wife.
So when I say I'm going well, what does that mean?
Are you doing well? You can keep going.
Keep going, all right. You tell me to shut up when you need me to shut up. All right, I just want to touch on a second scenario, which of course doesn't bear any resemblance to true factual circumstances whatsoever. But just to show where things can get a little bit worse in a contractual environment. Let's say now you've got a contract with another company called Adventure Works Proprietary Limited, and this time it's a retail website. So whereas before it was an internal management system which was you were working on, now you're working on a retail basis that has a high volume. Once again, there's fixed price elements, but this time it's in stages. Then you know you tried to break down the fixed price to do. You know, you're going to do A, and then when A is finished, you do B, and then when B is finished, you do the shopping cart, and when the shopping cart's finished, you do etc., etc. Once again, there's also a variable element where there's going to be some parts of the work which is on a time and materials basis. And in this case as well, you've got a whole bunch of third-party component integration to take into account. And what you say in your contract is that where it's a third-party element work, you know, you really can't that can't be done as part of the fixed price agreement, because how can you provide a fixed price? It's hard enough providing a fixed price when all you're working on is Visual Studio and SharePoint to have a degree of certainty. When you're integrating with another third party docketing system or something like that, you've got more issues are going to emerge. And then of course you've got the issue of finally going live. And of course what happens is you work, do all the work, and then you make a decision to go live, and of course it all falls over at go live. And there's a lot of screaming going on at that point. Now, there's my snail in the bottle picture.
It's on the wrong slide.
It's on the wrong slide anyway. Got it in there somewhere. I just spoke about it too early. Waiver. I've talked about waiver, but I'll talk about this specific example. Where you say in a fixed price contract, the following items are excluded from the fixed price, you know, integration with third-party components. And then what you do is you just start doing work on third-party integration as part of the fixed price work. It's pretty hard at a later point in time to say, oh, actually, all that work which we did for that third-party integration, we should have billed you for it. Because what happened is you had a contractual right which you waived, said goodbye to. And this happens all the time in contracts where a written document says X and you don't enforce it. And this is a common scenario in any situation where you've negotiated the terms of a contract. You're a company, you've negotiated the terms of a contract, you know, with the client's lawyers or with your lawyers or just on your own, and you said these are the things which we can do, these are the things we're not going to do, this is excluded, this is included, all the rest. And then when you tell the developer, then you don't tell the guys in charge of actually doing the work what the terms of the contract are. And so what happens is the contract says X, the way the parties behave during the course of the contract is completely different. It's pretty hard then to go and enforce your claims against that person saying, well, the written document says X, because they're going to say, well, you waived your rights in relation to that contract. So, you know, it's always going to be an issue that if your developers ultimately, if they're If there are peculiar terms and conditions in a contract, they're going to be, they need to know what they need to do. It could be that you won't proceed beyond a certain stage unless the client has passed the software. You've sent it off for them for a test, please, or whatever, and the contract says you don't need to start stage 2 until they've passed stage 1, but you just go ahead and start doing stage 2 without them passing stage 1. Well, when issues emerge with stage 1, you can say, well, it was your responsibility to make it work and you didn't do it. So, well, you started work on stage 2 anyway. So if you've got a contractual position and you start waiving it and behaving differently than the contract says, you can really prejudice your position. Sorry, did not have waiver up there and I was banging on about waiver.
So what level do you see that's necessary to describe what you're going to deliver? Because it almost seems like, there isn't enough language to adequately describe what you're going to build at the beginning of a contract. Because sometimes it's not known and you can so have different perceptions about what you're describing in words.
All right, so the question is, for some reason I remember when someone else asked me a question, but when Greg asked me a question, I don't remember to do this. I don't know what it is about Greg. Anyway, the question is, to what extent do you need to describe what you're going to deliver as part of a contract? Well, I'll tell you what I think has really changed the landscape in this is been the advent of agile software development. Because what agile does is really good for the developer. Because what are you promising to deliver in an agile environment?
A week's work.
Yeah, a week's work. Well, I can deliver that pretty easily. But ultimately, that's what that has done is shift the description of the work from the delivery of particular specification to delivery of time. And it's basically, it makes sense why software developers want to push an agile approach to software development, because it means that they don't really have any liability as to what they're going to produce. It's completely open scope. We'll try and do work items, 21 to 40, but if we only get 21 to 23 done, that's all we got done, I'm afraid. So I guess my answer to your question is, if you're agreeing to do a certain piece of work, then you're obliged to do that piece of work. And you need to adequately describe it to protect you. They're going to try and adequately describe it to protect them. But once you start arguing about, the precise functionality that's going to be delivered over a big software project, you're going to get into arguments about what's included and what's not included, because we don't do these, waterfall business use case diagrams anymore, do we? That doesn't happen much anymore.
Well, you still do it, but you don't try to do the whole thing. You're not trying to boil the ocean. And I'll tell you that I know you're looking at it from a legal point of view, but a big thing that Agile does is stop that adversarial type of relationship.
Yeah, no it doesn't, but anyway, not in the end. But it's adversarial when it comes to court, no matter whether you got on earlier on. But I understand that it's a more collaborative approach with the client on the way through. And so I think what Agile does as well is ultimately, if I put it crudely, it lowers the expectations of the client as to what they're going to get. It says we'll do our best to do X, but we might only deliver a bit less than that. And when I say lower the expectations, perhaps what you're really doing is just sticking to what life is, that it's very difficult to deliver final functionality in a limited period of time when you've got limited time, limited budget, and they want massive scope. So what Agile is about educating clients about a way that works better for you. So the question becomes, if you've described something that you've got to do, then you've got to do it under the terms of the contract. And if there's ambiguity about it, then the courts can start intervening. But I think if you're thinking about how to better protect your liability as to production of a result. What you want to start doing is more billing on a time materials basis and less on a fixed price basis, work with variable scope. And once you've developed a course of conduct with your client that says, we aim for this, but if we deliver this, and then they accept that and pay the bills and you move on to the next release, then you started showing a course of conduct between the two of you about what was actually going to be expected as part of the project, which is a lot less than what you would have done if you'd written out the scope from the beginning. There we are. I was going to talk about negligence then. I've talked about limitation of liability clauses already. The rule is, another legal term is, these kind of clauses where you're trying to limit your liability, when it comes to court, they're, in the case of ambiguity or generally, they're interpreted by the courts contra proferentum. So they're interpreted contrary to the person that they prefer. So if you're the person that the clause prefers, that is, your liability is being limited, the courts may well interpret it contrary to your interests. So that's why these limitation of liability clauses should be treated with a grain of salt, and you should never really rely on them, because it might be interpreted against you down the line. Mitigation of loss is a really crucial aspect. In that scenario where you have a retail website that crashes on deployment, what do you do?
Fix it.
You roll back. That's right. And the owner of the website can't sit there and watch sales just crash and money be lost and kind of rub his hands and say, great, we're going to sue the software developers for every dollar that's being lost here, and if it takes him 3 months to fix the problem, then we'll get onto it. There's not a lot of people that act that way anyway, but the point is that that's a possibility, the way someone could behave. You have an obligation, if you're a party that has had a contract breached against you and you're suffering loss as a consequence of that breach, you have an obligation to mitigate your loss. If you have if you're a landlord and you've got a tenant that walks out, before the end of the lease, breaches the lease, the first thing you've got to do is start advertising for a new tenant. You've got to mitigate the loss. You can't just say, great, I've got an empty place here, the market's rubbish, I'm due to get $5,000 a week from this guy, I'll just cash in because he's meant to have 10 weeks left on his lease and he's left early, I'm going to get his $50,000 out of him. You can't just sit back on your laurels and watch that happen. You've got an obligation to do things to mitigate your loss. So one of the things you should do in that situation is have a rollback plan, with a website, so that if everything falls over, you can get back to a position where everything's working. One good breach doesn't deserve another. People often think, when my client stops paying me, I'm going to stop doing the work. Does that sound fair? It sounds very fair, doesn't it? And it's how we all feel, and it feels like that's the way the world should operate. But simply someone else breaching a contract doesn't necessarily mean you have a right to breach the contract. Because if their contractual obligation is to pay you $5,000 a month, and your contractual obligation is to do certain work when they ask in a month, simply them not paying you $5,000 doesn't mean you can decide, to stop doing the work when they call and ask. Now, there's a whole bunch of rules that's going to govern what actually is the case in that scenario. One of the issues is going to be does the contract say, if you stop paying me, I can stop doing work? Well, if you've agreed on that term, that's great. You might want to rely on it and say, stuff it, I'm not doing work for you. But what if they've not paid you in the past and you've kept working? Have you waived that contractual right? So remember, you can always lose these rights that you have the way through. But sometimes that's a really distasteful thing to a situation to be in, where you feel like you've got to do work and the other side has stopped paying you. And it comes to a point where you've got to work out whether you are going to terminate the contract or not. And And it might be that you need to get to that point to finally stop the obligation of you having to do the work. But a right of termination could exist in a whole series of different ways. Often contracts say this contract can be terminated on with 30 days notice. So you might say, well, I'll do work for you up until the end of June, but on the 1st of June I'm going to send you a notice saying I'm terminating this contract with 30 days notice. You don't even reference the fact they haven't paid you. You're just saying I'm terminating the contract on 30 days notice, and then, because that's what the contract says that you can do, and then you walk away at the end of June, but you keep doing what you meant to do under the contract for that period, and then you go and sue them for the money that they owe you. So don't just start thinking you can play tit for tat in contract situations. Because, and I'll use this word, repudiation. Repudiation means that you evince an intention that's contrary to the terms of the contract. So if you start saying, look, I'm not going to do the work even though I'm contracted to oblige to it, they may well go and terminate the contract on you and say you repudiated the contract because you decided you didn't want to be bound by the contract. And if they then suffer loss, because you repudiated the contract and didn't provide the service that you were meant to provide, then they can sue you for that loss. So you need to be very careful about downing tools.
Cameron, one of the things I put in my contract is non-payment of contract as a material breach. Is that good enough?
Okay, the question is, can I say that a non-payment of contract is a material breach? Yes, you can say that, and yes, that is useful. Is it going to be determinative of the question? Hard to say, but it's a very useful thing to say, because there are certain circumstances in which anyone can terminate a contract, and one of them is if there's a material breach of a contract. A simple breach of a contract doesn't entitle someone to terminate a contract, but a material breach is a ground on which you can terminate, and you can contractually agree what a material breach is. So that's going to give you some pretty strong basis, but even so, you'd want to be careful about how you've operated in the past to make sure you haven't waived that term of the contract, and you'd want to be careful about the notice that you give and to act reasonably. But yeah, it's a very good start to define what your material terms are. All right, just other important learnings that come out of some of the things we've talked about. I have actually said this already, that lawyers account for the worst possible scenario. At the beginning of a contractual relationship, you're always thinking positively and trying to get on. But what a lawyer will do, if it's reviewing your terms of your contract or giving you advice, will think, what is the worst possible situation that can occur in this contract, and have we provided for it? So that's why lawyers are often look at things with a negative outlook, because that's what we're going to get sued over later on when we haven't told you about the worst possible situation. A very practical factor in any software dispute or contractual dispute is the cost of litigation. The first rule is that the cost of conducting a litigation bears absolutely no relationship whatsoever to the amount being argued over. So if you're arguing over $10,000 or $100,000 or $100 million, there is not necessarily a direct relationship between how much you're going to pay your lawyers to argue over those amounts of money. The classic case is building contracts, where there's an awful number of things going on, and it's similar perhaps in the old time materials basis in software contracts, where you just go on site and do what you're told to do. There might be a written agreement to start with, and then you go and do something else that that Bill or Barry or Jeanette tell you to do, and then there's this other work, and some of it's subject to a written contract, some of it's subject to an oral contract, some of it there's no contract as a quantum merit basis. You could be arguing about $10,000, in a court, and you're going to ultimately spend 30 grand on a lawyer. because you can't walk into the Supreme Court for less than 20 or 30 grand in reality, and that's, like software estimates, double it, So you need to think very practically when you're in a software dispute, just like this gentleman said over here about there was a disagreement with a travel company about whether something was to be provided or not. Often in a commercial, you take a commercial approach to these disputes, and no matter what your lawyers say are your lawful rights and obligations, it's a whole lot better to solve your problem outside of the courtroom, because you're just going to end up with a lot of stress and a lot of fuss. And in my experience, being a litigant is like a full-time job, because you've got to give witness statements, you've got to talk to lawyers, you've got to have meetings about what you're going to do with this case and with this offer, and what happened then, and get all this evidence together. You think piles and piles of papers of evidence and affidavit material. It stops you working in your business, and it gives you another job, and it's an enormous cost.
So in your previous example, you there said like somebody hadn't paid you for 2 weeks' work at $200 an hour, so it's like $16,000.
Yeah.
So with something like that, just you wouldn't ever chase that up in the court?
No, I'm not saying I wouldn't chase it up in the... Sorry, the question was where you are arguing over 2 weeks' worth at $200 an hour, would you bother chasing that up in the court? So what's that come to? $16,000, is that right? So in that kind of situation, you're in the local court. The question becomes what are the factual issues in argument on that basis? Is the other side saying, look, there just wasn't a contract. We know you turned up, we know you did the work, and we were happy with the work, but there was no contract, so we've got no basis to pay you. Then that's a lay down misere to walk in there, file a claim on quantum merit, go and get your expert evidence, and go ahead with that. But that's never the case, is it? What they're going to say is that something didn't work, or that you did something that hurt them and cost them money. And so it starts then getting into an argument about not simply whether you did the work or not, but whether the merit of the work, the value of the work, is actually what you were claiming. And so you start getting in a more complex argument then about what what's going to be about what the value of the work is that you should be paid. They're going to bring an expert along and it says it's only worth $55 an hour. So in that situation, you really want to think commercially. You'd want to instruct a lawyer that takes a reasonable approach to these situations. And I would say, more often than not, you're probably going to have to come to a compromise when you're in a dispute like that, and compromises hurt. And one of the reasons why I think you need to compromise in situations like that is that even if you win in that case, you're in the local court. The costs that you get in the local court are very limited. You might pay your lawyer $6 grand to argue a case like that. Even if you win everything, you might only get $2 grand back. The courts don't encourage people to litigate. They don't make it so that you go in there and win, and we'll reward you with gifts from heaven, for winning a case. They basically, yeah, you win, but you've lost a bit too. So that means you're out of pocket $4 grand already. That means that it would have been better for you to settle for $12,001 when you were claiming $16,000, and it also probably means that you won't have spent, a whole lot of stress and time away from your business earning money. Now, if you're arguing over less than $10,000 in New South Wales, you're in the small claims division. And if you're arguing over $10,000 in the small claims division, the most you're ever going to get awarded in costs is about, I think, $800. So, whether you're arguing over 1 week's work for $8,000 or 2 weeks' work for $16,000, it's the same argument. It's the same legal principles that apply. What's the value of the work? Did you cause damage while you were there? Is there a contract? All that kind of stuff. 3 weeks, 4 weeks, it's all the same argument that's taking place. So there's just no economy of scale in arguing over smaller amounts of money. So look, it's in my interest that you litigate everything. But, you'll hit me in the courtroom just like that other guy got hit, because it's just madness. It's not in my interest in the long term to make you litigate, because you just get annoyed. A really important aspect, I think, to protect a software developer in a contract dispute is to have your system live. The great risk in software development is to have a system that doesn't do anything, doesn't add any value to your client, because they've got no reason to try and resolve the problem. They've got no pull to get you back in there and to fix the problem, to get things cracking. Because there's this thing that's dead, it's in the corner, it's not providing any value, it's not doing anything for their business. So if you have a live system, you know, there's a real incentive for that customer, for that client, to get you back in there and working on the system, because they need you, number one. And secondly, they've at least got something that's of value. And in my experience, the greatest software disputes are the ones in which you're arguing over something that doesn't do anything, because it's a dead duck. If you haven't got a system live, it's not a good look either. You walk into a courtroom and say, I spent 4 months doing this thing, I never quite finished it because they stopped it, and it doesn't actually work because it's got heaps of bugs in it, but I want to be paid for it. You know, it doesn't start you on a good footing and giving a good impression of the judge about what kind of professional you are. So, and that's how I understand is Agile. The purpose of Agile is to get something live as soon as possible, and I would encourage that approach as a way of practically resolving the problems.
We refer to it as minimum viable product.
Yeah, absolutely. Minimum viable product. Minimum viable contract too. If there's a whole bunch of things you can't agree with a client, just agree the minimum, and then at least you've got a contract. You know,
someone tweet that.
Let's say on this $150 or $200 an hour one, you say, look, I want 200, they want 150. Look, I'll do a day at 170. Okay, come in for tomorrow at 170 for a day. But that's it. I'm not doing any more. You know, deliver them some benefit, they might go, all right, come in. Who knows? I'm just saying, you don't want to be arguing on a quantum merit basis if you can avoid it, because, you know, the quantum merit requires some kind of expert to come along and say, what's the value of this work? If you've just agreed on 170 for a day, then at least you've got a basis of a claim that's in contract. So, yeah. What's the phrasing in Adam? I've forgotten already. Minimum viable contract, there we go.
Now, what about the minimum viable contract? You don't need to go engage with the client on the basic terms that you think should be in a contract.
Well, yeah, look, it depends on the situation. Sorry, the question is, thank you. Isn't that what's that? Yeah, no, I understand. Anyway.
Actually, before you repeat it, what I'm going to say is we would never negotiate a minimum viable contract because we want to make sure that we're protected fully, not minimally.
Okay, so the question is, are you really saying a minimum viable contract is what you want to do? Don't you want to properly protect your position? And I would say, well, yes, of course, but it depends on your commercial situation. The example I gave was a single software developer arguing over whether he's going to get $150 or $200 an hour. But what the great issue is where, the case where a major quantum merit was claimed was a building and construction case in which everything was agreed in the contract other than the term of liquidated damages. Does anyone know what liquidated damages terms are in contract? That's where often in building construction, if you don't deliver by a certain date, a delivered product, then you, even though they're paying you pay them $200 a day or whatever for every day you're late in delivering what you meant to deliver. And what happened in that situation was the two parties agreed on everything other than the liquidated damages clause. And what happened was the judge said, you know, it's a bit crazy, but this is what the judge said, no contract. Even though they'd agreed on everything, there was no contract because they hadn't signed the document on the basis that there was no liquidated damages agreement. So what I'm saying is in those kind of situations, you're left with a claim in quantum merit to get your money if you start work. Now, the point is, will you start work without a signed document or without an agreement? I would say that in many cases people do. So what my point is if you're prepared to start work without a signed contract, and the question of signature or no signature is not necessarily determinative, but in what I'm saying is without you finalising all the terms of the agreement, you're prepared to start work, then you're exposing yourself to having to run a claim in quantum merit down the line, which is possible, but it just makes it more challenging. So this happens all the time, doesn't it? You've got like a heads of agreement or agreement to agree. Look, we're going to start work now, but we were going to enter into a contract down the line. You want to avoid those kind of situations by at least agreeing on something. We're going to do 2 weeks at $200 an hour. It's scoping work. The intention is at the end of the 2 weeks that we'll enter into another contract with a better description of the work we're going to deliver. But what you do is you get terms and conditions signed saying you're going to work at $200 an hour for 2 weeks.
So, well, I have a slightly different take on that from a commercial point of view. It doesn't, if it's a big system, it doesn't hurt to, if they'll agree to pay you for a week's worth of work before you get a contract, they get to see if they like working with you, at least you get paid for that chunk. Yeah. And you won't move forward until you got the whole thing.
Absolutely. Well, that's the minimum contract that you're willing to move forward on. You've got something agreed. Yeah.
So I have a question from Eric Fan, and he says, look, you understand...
Where is he? Isn't he in the back?
He must be at home. So he says, look, I understand if you develop a site and it crashes and they lose sales, how you calculate damages. But what about in the other case where you're working for a client on an existing system, you develop a new site for them and it's gotten to the point where it hasn't gone live, but then they start suing you. How would they calculate damages? Because they can't sue you for lost sales.
No, they can't. Well, they might find a way if the new site was promised to do all sorts of things and it wasn't delivered on time, and so it was never deployed, and so they were going to make this amount of money out of the site, and they didn't because it never went live. The damages in that situation is, well, they've paid you a whole lot of money and not got anything out of it. So the damage is probably more limited to the amount they've paid you in that contract.
So is that referred to as like reverse quantum merit or something?
No, that's just that's what's called reliance damages. So they, it's not strictly true, but it's simply what was meant to be paid under the contract, which was lost. Right. Yeah. So there's kind of a whole series of lots of damages. There's expectation loss and all the rest. We would have got this if this was in place. But yeah, it's a limited amount of damage. So what that means is if the site's not live, then you're limited. You perhaps got limited damages if there's no retail effect. But and say, oh, that's great, we've limited our damages. But the point is it's best to have a site live as early as possible. Sorry, there was just Mehmet had a question before you, sir. All right, great.
I think from a practical aspect of Agile, it puts a framework where you can change things and allow things to improve. I think the other important aspect is that when you're estimating it every 2 weeks, you're continually saying this is the work we've done, plus this is now the new estimate of the work to go. So you don't get those nasty surprises. In the past, lots of companies have got sued because they were never told up until the end that we were still only halfway through. Yeah. And so they said, well, you've got nothing at this point and all the money's run out. And that's why I think from a practical aspect, if you can continuously update what you believe the work's still to be done, you actually get protection from the software provider, but it actually puts the customer in a far better frame of mind because they know exactly where you are and how much more money's got to spend.
That's right. So that was a comment, just for everyone else, generally that what Agile does is set everyone's expectations and keeps everyone's expectations up to date with what is actually going on in a software project with what are they called, debriefs and reviews or whatever, all the retrospectives. When they're happening regularly, the client understands what's going on, and a really important point in any contractual or business relationship is setting expectations. And as I say, I think if I put it crudely, what Agile does is lowers everyone's expectations to deliver this. We'll deliver this much, but we're not going to deliver this much. And obviously the old waterfall approach is we're going to deliver everything in one bang. And what Agile does is say, no, we're going to limit what's delivered to being something that's effective and live early on.
So Cameron, can I put that another way? I had a client who came to us and they wanted to do a project just to feel what Scrum was like, just a small project. And he said at the end of that, oh, Scrum, it's just a forced way to communicate. So you might say lower expectations, but often you're not communicating very well.
Right.
And reset all the time.
Yeah, I'm stating something in the worst possible case to think of it negatively, and particularly what a strict contractual advantage it has for software developers. But ultimately, it's about delivering what you agree you're going to deliver, and you're more likely to do it, I think, because you're always adjusting what you're agreeing in Agile. Covered that. Spoken about this already. Keep diligent written records of what's going on. An important part when you're sending an as per our conversation email, don't say as per our conversation, I will do this work requested by Brooke to do this screen. Please reply, I agree. Because what that means is that is that actually an offer? You know, and that you need an I agree for him to accept your offer. What you want is just a statement of the facts. You know, if you have agreed, this is what we agreed. We agreed I was going to do this work that Brooke requested, and we estimate, 5 days. And that way you're setting out an agreement and you're not exposing yourself to giving evidence that there was never actually an agreement, there was only ever an offer which was never accepted.
One of the things I put on that sort of email at the end of it is, let me know if I've made a mistake in this, i.e. leaving it open for them to get back to me, but only if there's a mistake.
Yeah.
Repeat.
Should I say, let me know if anything in here is incorrect? Yes. Look, I can see pros and cons because you're inviting them to say there's a problem. And you might just want to say this is the way it is, folks. And unless if you're stating a truthful statement of facts about what was agreed or not agreed, then say it. Say it confidently. Don't kind of say, look, I'm sorry if I've got any of this wrong, because you're setting the relationship up to say, I'm always getting this wrong, and you can challenge me what I say. You just say, this is the way it is, and if it's got to be true. But if you're saying this is the way it is, yours faithfully, then leave it at that. Let them come back to you if there's a problem. I think it depends on the relationship, but I think contractually it's better to say this is the state of affairs. And if there's an error with it, and they've got notice of it, and they didn't comment, then because what it's an argument about in the future is a factual argument about the judge is going to have to decide, what were the facts? Was this agreed or was this not agreed? If you've got an email that's made at the same time as the agreement was made orally that says this is the state of affairs, my view is that a judge, depending on your credibility as a witness generally, but a judge is going to prefer your view of the facts than someone else who says, well, I was there and I remember it differently. Did you make a note about that? No, I just remember.
Could the other party say, like, oh, I never received this email, or this disappeared in my message email inbox?
The question is, could the other party say, I never received the email? Well, of course. That's always something they can claim, but there's plenty of forensic computer guys that can dig out emails. and I've been involved in cases where there's a question about whether someone who sent an actual email, and you get the forensic computer guys out and they dig out the hard drives. They can tell you pretty easily whether an email was received or not. Yes, that's where the power of the court process comes in. You start subpoenaing things. Hard drives and everything. So yeah, and when someone denies, there was a case today that was reported by Law Cover, which is the professional indemnity insurers for lawyers, and the argument was whether a particular document had been received by a client. A client had done some work for a solicitor had done some work for a developer. They'd had a dispute, but they resolved the dispute, and what the developer did is, we want our file. And so the solicitor gave his physical file, and lawyers have physical files. We print everything out. It's completely archaic, but that's what we do. And gave the pile of papers to the developer client. The developer client then sued the solicitor, saying, we told you this, and you didn't act on it. And because you didn't act on what we told you to do, we've suffered an enormous amount of loss, and we're suing you for it. And they got an expert in to look at this document, and they showed that the receive stamp on that particular letter was not the receive stamp which the law firm had been using for 10 years. And so it was proven that someone on the developer side was dishonest. Who knew whether they were dishonest or not is I don't know if it's a point that the law decided which particular officer of the developer actually put the fake stamp on and gave the file into the court. But once you're starting fabricating evidence, it's all over. So yeah, you can lie to the court, and but there are good ways of computer forensics now to find out when a file was first created, when a file was modified, all that stuff. Was there another question? All right. Touched on this already, but a statute of limitations is very important. If you have a right in law, that right doesn't exist forever. You have to act on it. In negligence, I think it's 6 years. In contract, it's 6 years. Time starts to run from different points. In contract, time starts to run from the breach. When was the contract breach? In negligence, time starts to run from when the damage or when the negligence was reasonably ascertained by the person who you were negligent against. So you get a bit longer in negligence, generally in contract. But once that time ticks over, it's all over. You lose your rights. So it's a very important aspect. If you've got queries about that, always speak to your lawyer. All right, that's it. Just in summary, what I've tried to talk about today is the rights and obligations that you have. Contracts work both ways. You get rights and you have obligations. It's really important to try and define those. What I've said about Agile is that what your obligations are is essentially you have to act in a workmanlike manner and exercise due care and diligence. You can't turn up and play solitaire or whatever for 40 hours and bill them and say, there it is. You've got to do what you said you're going to do. But what Agile does is basically try and limit your obligations less to producing a final product and more to something other than that. Rights and obligations exist outside of contract. They exist in negligence. They exist in the Australian consumer law, in statute and other aspects. When it goes wrong, I've tried to say, conduct negotiations, try and resolve problems amicably, or try and resolve problems with the commercial hat on, not on the basis of principle. Always protect your position, state what you think the state of affairs are. Assert your rights the way through. Keep sending invoices, even if you think it's going to upset them that you're still billing them, because you need to keep saying this is the contractual position that I'm asserting, because as soon as you waive your contractual rights, you're at risk of not being able to enforce them down the line. You get sued because you don't deliver something in the end. So try and get something live straight away. And the best solution is call your lawyer. Thank you.
Did you get all that? We'll take the SSW TV quiz and test your knowledge now.